So what exactly is intellectual property? Simply stated, it is anything that we either create or invent from which we intend to receive some kind of benefit or recognition, and usually that benefit is financial. There are four broad categories to intellectual property. The first and most prevalent one that we see with software is copyright. Copyright is about the expression in some tangible form of an original idea. Lines of code that make up software is copyrightable subject matter. Where copyright is about the expression of an idea, trademark is about branding. Copyright and trademark are often confused as being two words to identify the same thing. In fact, they are very different, albeit related. A company's external identity, its name, its logo, those are the stuff of trademarks. Perhaps the most complex area of intellectual property are patents. Patents are things that we invent. The smartphones that most of us have are covered by many patents. There's a long-running debate on whether or not software, which clearly is a subject of copyright, can also be patented. While I will discuss what is patentable subject matter, suffice it to say for now that the business processes and algorithms that software enables are in fact patentable. The fourth and perhaps most often forgotten and misunderstood IP law concept is the trade secret. As the name implies, part of what makes a trade secret is the fact that it is secret, meaning that it is not generally known to the public. Common examples of trade secrets are things like the Colonel's 11 herbs and spices with Kentucky Fried Chicken, the Coke formula, and even Google's search algorithms. With that background on intellectual property, what is intellectual property law? Well, it's the set of laws that protect intellectual property, and there are several sources of law as well as organizations within the overall legal framework. The body of laws that make up intellectual property law is vast and at times can be quite complex. For the most part, in the United States, the jurisdiction around intellectual property law is federal. That said, there are cases where state law can also govern. Two such examples are trademark and trade secrets. As to the federal law in the United States, the statutory authority derives from the U.S. Constitution. In addition to the statutes, there are regulations and case law that interprets and enforces those statutes. The United States is also a signatory to a number of international treaties and trade agreements. With respect to governing bodies and organizations, in the United States, the two principal governmental organizations are the U.S. Patent and Trademark Office, or USPTO, and the U.S. Copyright Office. In the European Union, there is the European Commission and the European Patent Office. In Asia, there is the Asian Intellectual Property Exchange. Perhaps the best-known international organization around intellectual property is the World Intellectual Property Organization, or WIPO. It's important to know and understand the various governing bodies and organizations around the world, as you may have the need to not only register and enforce rights in the United States, but abroad as well. Getting back to an initial question at the beginning of this course about whether or not an image from a website could be used, I'm often asked whether or not a particular action constitutes infringement, or whether or not something is either patentable, copyrightable, or could be a trademark or a trade secret. While there is the body of law that defines the contours of intellectual property, the law itself doesn't exist in a vacuum. The analysis around most things with intellectual property is very fact-intensive, and often those facts are in dispute, as between a plaintiff and a defendant, and that is what gives rise to litigation. For example, assuming an image is protected by copyright and thus not in the public domain, one set of facts would lead to the conclusion that infringement has occurred for which damages could be awarded. Another set of facts that may share a lot of common characteristics with infringing activity may nevertheless give rise to a successful affirmative defense under fair use, and thus there would be no awardable damages in that case. Unless and until for a given case there is a trial, such that all the facts are heard and are evaluated against the law, we never really know for sure whether or not there is infringing activity. We may know within a certain degree of probability as to whether it's more likely or not that infringing activity has occurred. It's also important to note that the law is made up of both statutes that have been passed by Congress and signed into law by the President. There is the case law from judicial opinions that interprets those statutes. Through time, some given activity, because of new people sitting on the court or new and novel factual circumstances, such as the advent of new technology, that same activity may or may not be deemed to be infringing on another's intellectual property's rights. All of this goes to how complicated it can often be in determining whether or not infringing activity has occurred, or whether there are protectable intellectual property rights. This is why, quite often, companies will elect to settle the dispute as opposed to litigating the disputed cases. Cases such as the recent Oracle versus Google copyright case involving the Java language are the exception, not the rule. For purposes of this course, it's important for you to understand that conclusions, insofar as intellectual property law is concerned, is often far from being a black and white matter.